Hello, Winston-Salem Forsyth County School coaches, and welcome to the training for the 2022-2023 school year. My name is Amy Rich, and I'm a staff attorney for the school district. Also presenting today will be Dion Jenkins, our general counsel. Today's presentation will be divided into two parts. In part one, I'll talk with you about the rules and regulations that govern the interactions and communications between coaches, students, and others. I'll also talk with you about leases and other contracts and the authority that you have or don't have as a coach to enter into those agreements. We'll touch on the issue of confidentiality of student information, highlighting FERPA, the federal law that governs the privacy of student records. I'll speak with you about tips and information regarding safety and equipment, and finish out part one with a discussion about rules and guidelines regarding travel and field trips for your teams. In part two, Ms. Jenkins will focus on the athletic eligibility with respect to students with disabilities. She'll also speak with you about rules and regulations that prohibit recruiting in athletics. She'll touch on issues related to medical for students and finish out with part two on a discussion about First Amendment, free speech and religion, and things you need to know and understand in your role as a coach in this district. Let's go ahead and turn to part one, starting with a discussion about interactions and communications between students, coaches, and others.
Let's move on to interactions and communications. We're talking about all the different interactions and communications that go on between coaches and students and others when it comes to athletics. So, some words of wisdom. Avoid the appearance of impropriety when interacting with students. This means you should avoid being alone in your office with a student or transporting a student in a vehicle by yourself, if at all possible. Coming home late from a track meet, you really want to make sure that you're not alone in the vehicle with the student. When you have to communicate with a student, use school system resources. Use your school system email, the school system approved communication platforms. Don't interact one-on-one with students on social media. So if a student tries to friend you on Facebook or Instagram, decline those. Don't send text messages to individual students. Of course, this wouldn't apply if that student happens to be a member of your family. Now, we do have rules in our district regarding texting students, and you can find them in Administrative Regulation 1111. Employees and school volunteers, which include community coaches, should not send text messages to individual students. When text messaging is used for a school-related matter, such as letting somebody know about a change in the practice schedule or the game location, please remember the following rules. Don't send a text message to an elementary school student. Use a group texting website to communicate with middle or high school students by text message, and invite the parents to join the group texting website. AR 111 also sets forth some other rules when it comes to texting students. Coaches, teachers, other staff members are not allowed to communicate with middle or high school students by text message unless the student's parent or guardian has actually provided that phone number for texting, and it is listed in PowerSchool as such. When it comes to texting middle or high school students, that shall be the only number upon which you add the student to that group texting platform. It has to be the number that was provided by their parents for that purpose. Now, keep a record of all texts sent to and received from students. Don't delete them, keep them so that you can demonstrate that all communications were school-related and for that purpose and complied with AR 1111. Interactions and communications Social media, of course, is a big thing that we think about when it comes to interacting and communicating with students, coworkers, and others. This district has published a social media guideline for employees, and I've hyperlinked it in this presentation that'll be provided to you. And I would encourage you all to take a look at it to learn more about the guidelines and expectations that the district has when it comes to the use of social media surrounding athletics and you as a coach in our district. All right, continuing on with interactions and turning to interactions again with students. Pursuant to Administrative Regulation 4116.5, all employees and volunteers are prohibited from dating, courting, or entering into or grooming for a romantic or sexual relationship with any student who is enrolled in a Winston-Salem Forsyth County school, regardless of the student's age. North Carolina has a law that says the same thing. As a teacher and or coach, it is illegal to engage in sex or a sexual act with a student, regardless of age. This is a felony offense, regardless of age. It does not matter if the student is 18 or older. Now, if you, as a coach in our district, have knowledge or reason to believe that another adult is inappropriately involved with a student, you are required to report the information to your athletic director, a school administrator, or the human resources department. You can also reach out to my office, and you have to do this as soon as possible. If you fail to report this, you may be subject to discipline, up to and including dismissal from employment. Along the lines of the different types of interactions that we have in our district, unfortunately, sometimes there are issues that we have to address of discrimination, harassment, and bullying. So, of course, Winston-Salem Forsyth County Schools prohibits discrimination on the basis of race, religion, national origin, color, age, military status, disability, or gender. And Title IX, federal law, protects individuals against discrimination and harassment on the basis of their gender. Now, discrimination, harassment, and bullying. What happens if there's a violation? Well, students who engage in this type of behavior are subject to discipline under the Student Code of Conduct, and employees who engage in this type of behavior are subject to discipline under the guidelines for employee discipline. Where does it apply? So the rules that prohibit the discrimination, harassment, and bullying apply at school, at a school activity or school-sponsored function, whether on or off campus, and that would be the athletic events that you all attend as coaches, whether they're a home game or away. At the bus stop, on the school bus, or other vehicle as part of a school activity. So when you're riding that activity bus to your game, these rules apply there, of course, too. And generally speaking, they apply anytime or at any place when the behavior has a direct and immediate effect on maintaining order and discipline in the schools. So what do we mean when we talk about discrimination? We mean you are treating somebody differently based solely on their membership in a socially distinct group or category, such as their race, ethnicity, sex, being pregnant, religion, age, or disability. Discrimination may be intentional or unintentional. And so, for instance, an example would be if a bus driver was concerned about a student who was pregnant and whether or not the pregnant student should be riding on the bus because there are no seat belts and the bus ride is rough. And the bus driver wants to require the pregnant student to provide a doctor's note for being able to ride on the bus and say that it's safe. Well, that's discrimination based on that student's condition of being pregnant. We don't require any other student to provide a doctor's note to be able to ride the bus. I don't think that the bus driver would be intentionally trying to discriminate against the student. I think they would say that they are trying to look out for the student's best interest. But nevertheless, they're treating that person differently based solely on the fact that they are pregnant. What about bullying and harassing behavior? It's any pattern or gestures, any pattern of gestures or written, electronic, or verbal communications, or any physical act or any threatening communication that places a student or school employee in actual and reasonable fear of harm to his or her person or damage to his or her property, or substantially interferes with or impairs a student's or employee's ability to perform at school or on the job. So unlawful bullying and harassing behavior includes behavior that is reasonably perceived as being motivated by one of those differentiating characteristics, such as race, color, ancestry, national origin, gender identity, sexual orientation, or a mental or physical disability. What does bullying look like? It can take a lot of forms. It can be making obscene gestures, pushing or shoving, being disguised as horseplay, intimidation or teasing, spreading false rumors, exclusion, or social isolation. If you have knowledge of or have reason to believe that a student is being bullied, harassed, or discriminated against, or if a parent reports this to you, you are required to report it to the athletic director or a school administrator as soon as possible. Under the law, the school district is required to take immediate and appropriate action to address that bullying and harassment and discrimination. So we need to know about it in order to stop it and address it. All right, continuing along the theme and topic of interactions and communications, it's important to talk about the civility policy. So policy 1170 sets forth the expectations regarding civility that the school board has for our district. Of course, profanity and other inappropriate language that is directed at students, staff, or visitors is prohibited. The policy also prohibits disorderly or disruptive conduct on school grounds. If you are an employee or volunteer coach included, you may be disciplined for violating the civility policy. Please understand that the rule doesn't apply just to you, all as coaches in our district, but it applies to parents, spectators at your games, anyone that comes onto the campus of Winston-Salem Forsyth County Schools. So if you are having an issue with a parent or a spectator, please notify your administrator or the school attorney's office. All right, so let's move to the topic of leases and other contracts and really talk about that authority to handle that type of paperwork for the district. So, do you have the authority to sign a contract? No, coaches are not allowed to sign contracts. If you want to buy something, if you want to hire someone, if you want to contract for services for a field trip or team travel, you need to check with your principal. You must get your principal's approval, and the proper process must be followed for that paperwork. If you obligate the district to spend money without the principal's approval and without following the proper process, you can be held personally responsible for paying that cost. When it comes to contracts, a particular type of contract is a lease agreement. And so just like the general rule with coaches not being allowed to sign contracts, coaches are not allowed to sign leases, nor are coaches allowed to informally lease school property to anyone ever. All leases of school property have to be handled in accordance with our board policy 1330. When we're dealing with a school-related organization, such as a booster club, that request goes to the principal. And other requests for use of our school property have to go through the operations division at central office. And the reason that we want to make sure that we are following this process, well, there's a number of reasons. But if an entity is using our facility, we want to make sure that they have the appropriate insurance in place and that there are the appropriate indemnification provisions in an agreement with them, so that if somebody gets hurt while using our property and it wasn't our fault, it doesn't become the responsibility of the school district or the school district's insurance company to foot the bill for that. If you do have a group that you want to use school property for, whether that's a club team, side business, or some other organization that you are involved with other than the school team that you coach, you must also follow policy 1330. That means that you have to do the lease agreement. You have to make sure you have insurance. You have to provide that certificate of insurance, and you have to pay the rental fee. All right, let's talk about the confidentiality of student information. So I'm sure many of you have heard the term FERPA. FERPA is a federal law, the Family Educational Rights and Privacy Act. Well, what is FERPA? It's a federal law that gives parents and students particular rights when it comes to educational records. And the basic premise is that a school cannot disclose the education records or personally identifiable information from those education records about a student without the written consent from a parent or eligible student. So, what is an education record? So, when we're talking about the ability to disclose an education record, it's important to understand what that is. So, we in our district have policy 5125, and the definition of education records is listed therein. And it's described as the entire content of a student's cumulative file and all other personally identifiable education records maintained by Winston-Salem Forsyth County Schools, which includes administrative records, discipline records, health records, educational records, exceptional child records, and they are directly related to the student. So when we're talking about a student's grades or discipline history, the incidents they have listed in PowerSchool, their attendance, what days they attended school, if they were late, if they were tardy, their disability status, if they have a Section 504 plan or an IEP. These are all things that are considered to be educational records. So what about what you know about the student? When it comes to your personal observations, they're generally not considered to be a part of a student's educational record. So if you have witnessed the student being late to class repeatedly, your personal observation about that isn't necessarily an educational record. But if you are the student's teacher of record and you are taking the student's attendance, and you created the record, you created the attendance record that is contained in PowerSchool, then it is protected by FERPA. So while your observations are generally not part of an educational record, if your observation is what led to the creation of the record, it is protected by FERPA. Now, there are exceptions to FERPA, meaning that we can disclose educational records without the consent of the parent or an eligible student in certain situations. And this means disclosing the records to teachers or other school officials who have a legitimate educational interest. This means that they need to see those records. Let's say there's an IEP meeting and they need to see what the student's psychological evaluation showed in order to help make a decision at the team meeting. They need to see the test scores. They have a legitimate educational interest in those records. There are times when there's a health or safety emergency, and perhaps we need to release the information to law enforcement to maybe find a missing child. When an official in another school system or school where a student seeks to enroll requests the records, so that the student can enroll there, we can provide those records. And there are notification requirements that go along with that in terms of notifying the parents. And of course, an exception to the general rule about not disclosing educational records is when we receive a lawful subpoena or court order. You can check out Policy 5125 and AR 5125 for a complete list of additional information regarding the exceptions to FERPA. But for your purposes, I think it's important to note another particular exception to FERPA, which is the directory information. So under Policy 5125, AR 5125, and the rules implementing FERPA, directory information is an exception. And here in our district, the Board of Education permits the publication in athletic programs and other school publications of a student's name, photograph, grade level, participation in officially recognized activities in sports, weight and height of the member of athletic teams, and honors and awards. The caveat is if the parent or student objects to its release in writing. So I'm sure that many of you put together programs or brochures regarding your athletic teams and have some stats and some criteria and some information about the players. And you might think to yourself, am I violating FERPA by publishing this? Well, as long as it falls into the category and definition of directory information, it's fine. But you have to make sure that the parent hasn't objected to the release of that type of directory information. So when it comes to FERPA, you have a duty to keep information confidential. And so if you have access to those confidential student records, you have to keep them in confidence if you've obtained that information in the course of your work, your professional service. And you're required to keep that confidence unless one of the specific exceptions to FERPA applies, or the release of information is permitted by law, or, of course, if it's necessary for the personal safety of student or others falling into that health or safety emergency. And this is information that's contained in Policy 4116.10. And so it's letting you know that this is your responsibility, and if you don't abide by this standard of professional conduct, it can subject you to disciplinary action. So just to recap, the general rule about FERPA and confidential student information is that unless we have a law enforcement emergency, don't release educational records, including electronic records, to persons or parties who are not parents without having a subpoena, a court order, or a written release from the parent saying it's okay to do so. This means talking about what is in those records too. So if the person is seeking a student's attendance record, if you can't share that information in the paper form, you certainly can't tell them what the information is by sharing it with them verbally. Winston-Salem Forsyth County Schools does have a standard form release that a parent can sign that specifically allows all education records or certain education records to be released to a particular party. And if you have a situation where a parent wants to be able to provide consent to release information to somebody, perhaps maybe it's a college scout wanting to know how the student's attendance and grades are, make sure that you have the form in place, and this will help you have a standardized form you can use. All right, turning to the issue of safety and equipment. So here are some tips and requirements. So look out. Be aware of the risk of flying objects. So we want to make sure that you're on guard and looking out for foul balls, sticks, anything that could potentially be flying through the air. We want to make sure that you are obeying any field markings or staying behind the safety apparatuses that are installed, whether those are fences or nets. It's important to model good behavior for your student athletes, and we ask that you demonstrate adherence to these safety requirements, not only for your own safety, but to help with the safety of others, including student athletes. Now, when it comes to the operation of equipment, before you are allowed to operate any equipment, you are expected to certify that you have done certain things. So I know many of you have responsibilities when it comes to maintaining your fields. And so there are pieces of equipment that go along with that. And so in order to operate that equipment, you have to certify that you've read and understand the entire operator's manual for the pieces of equipment that you'll be using, that you will inspect it to ensure that it is in good working order before you use it, that you will immediately report any defects, missing, broken, malfunctioning safety features, and other unsafe conditions to your supervisor, and that you will not alter or remove any safety guards, safety switches, or disable any other safety features on the equipment. You agree that you will wear at a minimum protective equipment that includes at least safety glasses, ear protection, and sturdy boots or shoes, which cover the entire heel, toe, and instep of your foot. No open-toe shoes, no flip-flops. That you will shut off the equipment when you are not using it, and that you will not leave it unattended. It's also going to be a requirement that you certify that you will not operate a piece of equipment when you are impaired, whether that's by fatigue, medication, drugs, or alcohol. Of course, if you're on school campus under impaired by drugs or alcohol, there are other issues there too. You are certifying that you're not going to use electronic devices such as a mobile phone or an iPod, while operating the equipment. Finally, on this form, you're certifying that you will report any unsafe condition or injury resulting from use of the equipment immediately to your supervisor. And finally, that you understand that a violation of the safety certification or any of the rules that you agreed to adhere to can lead to disciplinary action, which is up to and including dismissal from employment. So the form will be signed. It needs to be signed and returned to the principal and signed off on by the principal as well. All right, team travel and field trips. Know before you go. All right, so when we talk about field trips, this includes travel relating to extracurricular activities, and the field trip rules apply to travel associated with athletics within Winston-Salem Forsyth County Schools. And so the basic rule is that, the basic rules are that all travel has to be approved in advance by the principal. Overnight and out-of-state field trips have to be approved by the superintendent or the designated assistant superintendent. I think it probably should say area superintendent now. And that you have to have a permission slip for the field trip. So when it comes to in-state travel for athletic teams, you can have one approval and using basically one permission slip at the beginning of the school year or the beginning of the season to cover all of those regular in-state travel that will be occurring during your athletic season or the school year. The participation packet that we put together for athletics, it has a permission for the local athletic field trips included in there. When it comes to out-of-state or overnight travel, it does require a separate permission form for each event. And you need to make sure that the parents have provided that, signed that, and approve of their child attending. When we transport students, we can only do so if we have been registered as an employee or volunteer driver. And that process is administered through the Human Resources Department. And the Human Resources Department will require you to submit certain paperwork and fill out certain forms. Your DMV driving history will be checked, and this is something that has to be done on an annual basis by September 1st. When it comes to activity bus drivers, to drive an activity bus, you have to have completed the same training as a school bus driver. You have to have a pocket card. It's referred to as, I think the appropriate term is the school bus driver certification card. And of course, in order to drive a bus, including an activity bus, you have to have a current Class B CDL with the S&P endorsements. As a reminder, activity buses cannot make residential stops. They do not have the required safety equipment to do so. They don't have the stop arm, the walk arm, the red flasher. Therefore, you must use the approved bus stops for letting students off or boarding students onto an activity bus. You, as a coach, do not have the authority to let another entity borrow or lease our buses, including our activity buses. If you have the responsibility of driving an activity bus, please make sure that you are maintaining the keys in a secure location, coordinating with your athletic director on that issue to prevent buses from being stolen or damaged in any way. If you have an accident, regardless of how minor it is, you are required to report it to the transportation department immediately. I want to thank you all for paying attention during part 1. Dion Jenkins will be up next with part 2. I'll go ahead and thank you all for the service that you provide and things that you do for students in our district. It's a critical component.
With regard to athletic eligibility, we've already talked about some of the rules that could potentially exclude students for a period of time. But I want to talk a little bit about how we can include more students and allow increased opportunities for students to participate in athletics. And I'm talking specifically about students with disabilities. Students could have a variety of disabilities. Some could be physical, some could be mental, some could be, a combination of the two. Under the ADA, which is the Americans with Disabilities Act, school systems are required to make reasonable accommodations for students who have disabilities or other handicapping conditions. What accommodations would be reasonable will look different under the circumstances. So an example might be use of a golf cart if a student has a physical limitation that prevents them from getting from one area of the campus to another or from one athletic facility to the other. Another example might be providing a sign language interpreter so that a student can participate in tryouts or competitions. The key here is to think of an accommodation that could be provided reasonably and does not create some sort of an undue burden for the school. But the good thing is you don't have to make these decisions in a vacuum by yourself. In fact, I don't want you to. If you have a student with a disability who wants to participate in tryouts or participate on the team, I encourage you to keep an open mind about what that might look like. And contact your athletic director, your principal, or the legal department if you have questions, and we can help you walk through the ADA analysis to ensure that we're allowing an opportunity for all students to participate in sports. So turning from eligibility to recruiting. Under policy 6145.2, all employees must be aware of what their requirements are regarding the reporting and the handling of recruiting violations. No employee shall encourage a student athlete to transfer from one school to the other solely for athletic purposes, or to engage in some other type of illegal recruiting practices that might influence such transfer. Any employee who exercises undue influence to cause a student to transfer from one school to another for athletic purposes only shall be considered in violation of this policy and subject to disciplinary action. And disciplinary action could include some sort of suspension from your employment, or depending upon the nature of the violation, termination. Recruiting is defined as all indirect or direct or inferred written or other types of verbal attempts or communication in order to persuade or influence a student to transfer from one high school to the other for athletic purposes. Also, no student may be subjected to undue influence by either an individual or a group of individuals in order to cause or induce them to transfer from one school to the other for athletic purposes. So what does undue influence mean? Well, undue influence could look a lot of different ways depending upon the circumstances. But in general, it consists of actions that are taken solely for the purpose of soliciting or encouraging the enrollment of a student athlete in a particular school for athletic purposes. So examples of what could constitute undue influence include initiating or arranging communication or contact with a prospective student athlete or a member of their family, visiting or entertaining a prospective student athlete or a member of their family, transporting or arranging for the transportation of a prospective student to a different school, providing verbal or written materials, slides, film, or tape presentations that imply or explicitly say that one school's program is superior to that of another. All of these are examples of what's considered to be undue influence, but this is not an exhaustive list. It's possible that there could be information posted on social media that tends to tout one program over another that could be considered recruiting. But it's also possible that by virtue of you all participating in certain teams outside of school, that could be considered recruiting. And so keep in mind that if you coach or you're involved with other non-Winston-Salem Forsyth County School athletic teams, if you use that as a mechanism to solicit or encourage students to come and enroll in your school for, because of their athletic program or because of the superiority of your athletic program, that could be considered an undue influence and that would violate our recruiting policies. These recruiting rules don't just apply to Winston-Salem Forsyth County Schools employees, okay? They apply not only to employees of our school, but to the head coach, the assistant coach, volunteers, or other individuals who are affiliated with the program. So please keep that in mind. For coaches and athletic directors, make sure that anyone who is affiliated with your program or your team understands that they cannot engage in any sort of illegal recruiting. And if they do, that could potentially be imputed back to you, back to your program, and can cause potential negative outcomes for your team. So in addition to not engaging in unlawful recruiting, we all have an obligation to report known or suspected incidences of unlawful recruiting. And in fact, the policy requires that information about recruiting be available and posted in every high school building. The principal or the athletic director is responsible for informing the entire faculty that recruiting students to transfer from one school to the other for athletic purposes is a violation of the board policy. And whenever you, as a school employee, suspect that a student has been recruited, you have an affirmative duty to report the suspicion to the principal, your athletic director, or the program manager for athletics, which in this case is John Sullivan. And all allegations of recruiting will be reported and investigated. Okay, switching gears a little bit, I want to remind you about your awareness and your response to certain medical issues that might arise involving your students. Just as a reminder, all students must receive a medical examination at least once every 395 days by a duly licensed physician, nurse practitioner, or physician's assistant. This rule was actually changed by the High School Athletic Association a few years ago to allow for a longer period of time. It used to be 365 days, now it's 395 days. So in addition to this medical exam, a student also must have an up-to-date physical in order to participate in summer workouts. As I mentioned before, students who are absent from practice or other athletic participation for 5 or more days consecutively due to illness or some other medical issue must be released by a licensed physician in order to be readmitted to practice or contests. They must receive a written release to participate. But you might be thinking, okay, what if I get this note from the student that says they're cleared and I don't trust it? It doesn't look, legitimate. It doesn't look credible. Well, you don't have to accept it. If you honestly believe that this note has either been doctored or forged, or it doesn't look accurate, or if you have observed the student and you believe that they're not ready to return, that it's not safe for them to participate, then don't let them participate. Err on the side of caution if you have reason to believe that the student is too sick or too injured to participate. And you can also confer with your trainer or your team doctor or your volunteer doctor to evaluate the student and see if you can get a second opinion, or you can refer the student to another doctor for a second opinion. Additionally, if you have a student that suffers a concussion or a suspected concussion, it's extremely important that you not let the student return to play on the day they suffer the concussion and prior to undergoing the concussion protocols. Returning an athlete to play before they've completed these protocols can result in additional negative impacts to the student, some of which can be fatal. It's possible that the student could develop a recurrent concussion, prolonged post-concussion symptoms, or even a syndrome that's called second impact syndrome, which is often fatal. An athlete with a suspected concussion cannot return to play until they've been cleared by a physician. This is the law. We've had instances in this district in the past where students have passed away due to a concussion. And so this is incredibly serious. When you're in doubt about whether or not a student can participate, sit them out. Okay. I want to talk about the First Amendment next, because as public school officials, we have certain obligations with regard to protecting the rights of students to engage in certain First Amendment activities. And I'm talking specifically today about religion and speech. When it comes to employees and religion, remember that as a public school employee, you are acting as an agent of a governmental entity. And so governmental entities are prohibited by the Establishment Clause of the First Amendment to engage in certain types of activities. And so as a coach or as a public school employee, you're required to be neutral concerning religion while carrying out your duties as a coach. And when I say neutral, meaning you cannot try to force a student to adhere to certain religious beliefs. You cannot try to proselytize or evangelize to students. You must remain neutral when it comes to promoting religion or promoting no religion or reporting religion over no religion. You also, meaning you, the coach, the principal, athletic director, cannot lead a team in prayer. You cannot force students to participate in a prayer. You also cannot appoint a team chaplain. These are things that have been analyzed and addressed by our courts and have deemed to have been a violation of the Establishment Clause of the First Amendment. Our state statutes do address the First Amendment and religious practices to a certain degree, and this is in the area of student prayer. So under North Carolina General Statutes, students can initiate and they can lead prayers for other students who wish to participate, so long as they do it completely on their own. So this can't be something that students are required to do or compelled to do. This has to be something that they do on their own voluntarily. And you, as the coach, AD, principal, etc., can be present while students engage in this voluntary right to pray. And you can stand there and adopt a respectful posture, and you can, of course, ensure that others aren't being, disrespectful during this practice. But the key here is that it needs to be student initiated and student led, not forced or compelled by a public school employee. The other First Amendment issue that I want to make you aware of deals around the subject of student free speech. So I want to ask you to think about something. Do you have team rules that prescribe certain conduct expectations for your student? Do these rules prohibit a student from talking negatively about your team or your coach, or engaging in certain conduct that might display the team in a negative light? Have you ever disciplined a student for a post that they made on social media that you thought was a poor reflection on the team? Because if you have, there's some recent case law that prohibits certain types of activity like this from taking place. And the case that I'm talking about is the Mahoney Area School District versus BL case. And this is a U.S. Supreme Court case that was rendered in June of 2021. So let me just tell you a little bit about the facts. There was a student here, a female student, who did not make the varsity cheerleading squad. And so she was rightfully upset about that. Well, at home later that day, while she was off campus, she posted some messages on social media. And actually it was on Snapchat. And her message included vulgar language and gestures about the squad in the school, presumably. So for example, she had a photo of herself and a friend flipping the bird to the camera, along with a message that said, F the school, F cheer, F everything. Now, of course, it wasn't the F with the asterisk, it was the actual word. But she posted this on Snapchat. And, Snapchat is designed in such a way so that things that are posted disappear after a certain amount of time. But because this student was friends with many of other students on her team, as well as other students that attended the school, it quickly made its way around the team and ultimately back to the coach. And so when the coach and other school officials found out about this message, they suspended her from the JV cheerleading squad. Well, her family filed suit, and this case actually went all the way up to the U.S. Supreme Court. And the court held that while public schools might have a special interest in regulating some off-campus speech, the interests in this case that the school said they were trying to regulate were not sufficient to overcome the students' First Amendment free expression in this case. So the court said, there are several factors that can be considered by the school in deciding whether or not to regulate off-campus speech. Those factors include, posting about targeting individuals, naming a particular school, etc. But in this case, the student didn't do any of that. She did not target any specific individual. She did not name her school specifically, even though everybody knew what school she attended. And her comments were made on her personal cell phone over the weekend off campus, and it was directed to her friends. So the courts in this case did confirm that, yes, in general, schools have the ability to regulate speech. Schools have a special interest in regulating on-campus speech that materially disrupts the classroom or creates some sort of substantial disruption or an invasion on the rights of others. So that's on-campus speech. But this was off-campus speech that happened, and the courts were not so clear about what types of off-campus speech can be regulated. But again, if it causes a substantial disruption to the school environment, it's more likely that the school can regulate that speech or discipline a student for engaging in that speech. Also, if the speech that happens off campus constitutes bullying or harassment, or it targets particular individuals, or if it's a threat that's aimed at teachers, other students, or it involves the use of school system computers or a breach of some sort of school security device, those are examples of situations where the school probably would be within its right to regulate off-campus speech. But otherwise, it's going to be an extremely strict analysis. So I say all this to say, we need to make sure that we don't impose rules on our student athletes that interfere with their ability to engage in their First Amendment speech rights. And our policy on student conduct actually acknowledges this. And it says that nothing in the Code of Conduct is intended to limit a student's right to express their thoughts or opinions at reasonable times and places, consistent with the protections of the First Amendment. So in general, we can place restrictions on a student's right to free speech when that speech is otherwise unprotected, which means it's obscene, it's abusive, it promotes illegal drug use, or it's reasonably expected to cause a substantial disruption to the school day. But I wanted to make you aware of this most recent case because it actually is an example of something that could actually happen. So if you have these team contracts or these code, these conduct expectations, before you enforce those and try to suspend a student for engaging in certain types of speech or, activities that could be protected by the First Amendment, please call the school attorney's office and we'd be happy to talk with you through that analysis.
Well, we've made it to the finish line. Thanks for attending today's presentation. If you have any questions or concerns, please don't hesitate to reach out to the staff members in the school attorney's office. We're happy to help in any way we can. We hope that you have a successful academic and athletic year. Thanks for all you do for students.